too much of traffic on the border of Noida, Greater Noida.
Yeah, because of this reservation thing going on. Yeah. No, it's okay. So we are starting this session right now. Thank you. Good morning, and on behalf of CII, I welcome you all to this annual conference on competition law and practice on a virtual mode that CII is jointly hosting today with Competition Commission of India. It is my privilege and honor to welcome and introduce Shri Ashok Kumar Gupta, Chairman, Competition Commission of India, Ms. Zia Modi, Chairperson, CII National Committee on Regulatory Affairs and Senior Partner, EZB and Partners, Ms. Indrapreet Sahani, Group Counsel General and Chief Compliance Officer, Infosys, and Mr. Mihir Rale, General Counsel, Star and Disney India. Thank you all for your time and for joining this inaugural session of the Annual Competition Law Conference. I would also like to welcome Honorable Members Dr. Sangeeta Verma and Shri Bhagwan Singh Bishnoi, Secretary in Charge Madam Jyoti Jingar Behnot, Advisors Madam Payal Malik and Dr. Sanjay Kumar Pandey, and senior officials from the Commission, all the participants and friends from the media. Chairman sir, thank you very much for your presence in today's inaugural session. As you are kindly aware, this is the 7th year in a row CII and Competition Commission of India are organizing the annual conference on competition law. Last year, we were in Mumbai around the same time when the roadshow on competition law and practice was held in person in a physical mode. However, due to the pandemic and to maintain social distancing, we are having this conference in a virtual mode this year. Well, thanks to the technology, it is equally effective and well functioning as we save time and cost, and if I may say, more productive as we have an impressive line of speakers confirmed during the 2 days conference, deliberating over 4 focused sessions. We also have more than 600 people participating in this virtual conference. So thank you once again for your kind consent to let this annual conference continue to run on a virtual mode without a break. And sincere thanks to the Commission and especially to the advocacy team in CCI for all the support towards organizing this conference. I would also like to take this opportunity to thank and acknowledge on behalf of CII that the Enforcement of Competition Act and the establishment of the Competition Commission of India have helped set up a robust legal framework so necessary for the economic development of the country. Since its establishment, CCI has played a significant role to ensure fair and healthy competition in economic activities in the country for faster and inclusive growth and development of the economy, and effectively carry out competition advocacy and spread the information on benefits of competition among all stakeholders to establish and nurture competition culture in Indian economy. CII is engaging closely with the Commission in evolving the competition law in India and for the advocacy initiatives. As a proponent of healthy competition, CII has all along maintained that while there should be regulation of market fair play, the legal framework should not impede the steady growth pace of the economy, as competition is not an end in itself, but a means to achieve larger economic goals. CII works to create and sustain an environment conducive to the development of India, partnering industry, government, and civil society through advisory and consultative processes. Basis feedback received from members, CII continues to provide inputs to CCI on various draft regulations as well as provisions which need to be reviewed so they become more streamlined, easily interpreted, and well complied with. We have over the years, together with the Commission, organized number of interactions and sessions with industry members across sectors to help advocate the importance of complying with the competition law. These platforms enable open dialogue between the regulator and the regulated to ensure the antitrust regime grows and evolves in the country to be at par with global standards, while of course facilitating the growth of business and economy. While encouraging competition compliance by the industry at CII, we have been taking proactive steps for ensuring compliance with the competition laws. The Competition Act applies to decisions, rules, recommendations, and other activities carried on by associations of enterprises, including trade associations like ours. Whether it is membership rules, meetings and discussions, or compilation of statistics, we are making sure that members follow the do's and don'ts in true letter and spirit and to be on the right side of the law. Well, I will not take much time as we have an eminent panel with us today. Therefore, would like to conclude that as we are conscious of the fact that the working of the Commission and the competition law need to be in harmony with the evolving business environment and Indian economy, the Commission of India has indeed played a very significant role to ensure fair and healthy competition in economic activities and for faster and inclusive growth. With these remarks, I once again thank the Competition Commission of India for all the support and now hand over to Ms. Jia Modi, Chairperson, CII National Committee on Regulatory Affairs and Senior Partner, AZB and Partners for her introductory remarks and for moderating the session, please. Thank you.
Good morning, everybody. Great to be here, and thank you, Chairman, for making sure you had the time and you were available to participate in this discussion. Very grateful indeed to have you as our chief guest, sir, and we're delighted that you can give us your keynote address as the session concludes, the inaugural session. Also great to have Mihir and Indrapreet as part of the panel. Good friends, old friends, and of course have to know enough about the subject to survive because competition law is an integral part of each of their businesses. You know, I was thinking back to the times when the combination regulations were first introduced, and I remember rushing and sitting down and reading them, and first having a heart attack, and then engaging with the Ministry of Corporate Affairs and the then chairman to see how to, start working this new piece of legislation. Because as an M&A lawyer, I was very conscious of the fact that if this didn't go right, M&A practice wouldn't hold. So it was almost an existential issue for us as corporate lawyers to see that we work hand in hand with the Competition Act and, of course, its regulators. And I must say that over the period of interaction that I have had, our firm has had, and I'm sure industry participants have had, what is very gratifying is that the consistent open approach of the Commission to understand pain points, to try and fix them wherever possible, has been remarkable. When we started and everybody said 210 days and the world groaned and said, what is this stop clock that will start and, will it really take this much? And I remember voicing my concerns to the chairperson then, and he said, but we'll give it to you much before. Why are you worried here? And I went away, quite sort of pessimistic, kaise hoga, kya hoga. But to my utter delight and surprise, our approvals came out fast and furious. I think the Commission wanted to prove to the world that it was more than capable of delivering. And it was a very, very pleasant outcome. So now you look at what is happening in the same way during COVID. Again, when COVID started, I groaned. And I thought, oh my God, now what's going to happen to all our approvals? Because you are the gateway as the Commission. And if you don't get an approval, no deal, right? So we were sort of planning, what do we do? How do we have client expectation, client manager management? But, the staff has been working from home non-stop. Even all the combination hearings that are going on are basically going on without any disruption and without any, I would say, undue delay, and any issues that come up, at least our competition team tells us, are more than well addressed by the Commission itself. I think even virtual hearings have now started since the first week of November on Section 3 and 4 matters, which earlier, I think, because of issues on how to deal with confidentiality and all was in debate, but even that has now opened up from what I understand. The pre-filing consultations, which are critical to clients and the industry, have gone on, and the interaction has been more than satisfactory. So we really thank you as members of the Commission for having facilitated all these possibilities so that business moves on. Business has to move on. I think that the Commission could possibly consider even post-COVID, which I hope is around the corner, to allow certain interactive sessions to take place regardless, so that you don't have to go back to pure physical. And to the extent that it is efficient, confidential, and well managed, I think saving people the time and trouble to take flights, to travel unnecessary distances if they don't need to, if the Commission could also consider having an alternate new normal in certain circumstances, that would be a very good thing. What is also very gratifying is that the Commission has reached out to participants to understand what SOP should take place. Consultation takes place with all the parties before the SOPs are put in place for COVID hearings. And that again is very much appreciated. As the audience may or may not know, our commission was one of the first to actually issue an advisory on April 19, which basically recognized the economic hardships that were going to be faced by the industry during COVID times. And they put out a statement to say that they would be conscious of the fact that people would behave in a certain way, that it would accrue to the benefit of the consumers, enable the broken supply chain to reinstitute itself. And as long as they could see an improvement in the production of goods and services, they put out the advisory to say that we are aware, we know it's COVID, we understand patterns of behavior may change, and as long as it meets these tests and is of benefit to all, we are letting you know that we are not going to be unnecessarily harsh. That I think also gave a lot of confidence. Again, even when it comes to MSCs and other similarly placed industries, CCI has recently shown that it is willing to take a lenient view, recognizing that COVID hardship is a real factor. I think, as most of you may have been reading in the papers, the Commission has been kept pretty busy. If you look at it, the geo platforms made sure that the Commission was busy with Facebook, was busy with Google, not to mention the Alstom matter, the ABB Hitachi matter. So even though it's COVID times, we've not allowed the Commission to stay at home in their pajamas. They've been at it night and day. And once again, I can say, at least on behalf of AZBD, we've really appreciated the absolutely efficient way in which the Commission has been functioning. The geo deals were important, I think, just in terms of FDI, and the world was watching to see how we would respond. And I think we walked away with all 5 stars and all our boxes ticked. So thank you. One other thing that the audience, I'm sure, knows, and that all clients worldwide have appreciated, is the Green Channel route. And the smooth way in which it runs, provided, of course, meet the conditions of being eligible for Green Channel. But I think once the eligibility is established, at least we have found that the Green Channel route has worked seamlessly and is very conducive to the ease of doing business, simply because you just don't have to go through all the unnecessary paperwork, provided you are in different business activities, etc., etc. The other thing that is commendable, and I would request the Commission to do more of this, is really putting out market studies for participants like us and intermediaries in this space. It is very important to understand the approach and the mind, thinking, thought, and purposiveness of the Commission. When you see the report on e-commerce, You understand what are the issues and how is the CCI looking at it? How is it looking at price parity, deep discounting, exclusive agreements, platform neutrality? All these, when you read, you can go and give back better advice, frankly, to your clients. What is important is for the CCI and the Commission to understand the market before it starts investigating it. Once the Commission is got the domain, has got an understanding, has consulted with market participants, and knows the space, then the investigation becomes much more thorough, more efficient, frankly, and the outcome is almost always a better outcome. Again, you've launched a market study in the pharmaceutical sector as the Commission. That again is very important, especially in India. The whole drug supply chain, what is the sort of interaction between the various intermediaries, the thinking of the Commission, inviting consultation, and then putting out a paper where everybody can then advise their pharmaceutical clients, look, this is the way the Commission is thinking. So this is yes, this is no, this is maybe, this is dark gray, this is light gray. Very, very critical for us to do the right thing, really, which is what the Commission wants. I think I should also mention that the Commission has been busy doing its advocacy events throughout the year. I understand there was a virtual workshop conducted of the BRICS competition agencies in the automotive sector and the competition issues in that sector. The other organized advocacy events of the CCI include the 5th National Conference on Economics of Competition Law to understand the issues relevant to the Indian context. We also participated virtually in the ICN event, which was not held in India this year, but again, we were participants. We now see a bill with the proposed amendment, which will be tabled in Parliament. We're looking to see how that pans out keenly. But I think that, the clarificatory changes that CCI has brought out in relation to Form 1 and the notes, the new guidance notes to Form 1 are very, very useful for the practitioners and the clients at large. The urge from me would be if the CCI can, over the course of time, issue more guidance notes, because that is the hallmark of a mature regulator and gives guidance to the entire industry and frankly saves the time of the Commission itself. I understand that guidance notes have to be thought out very carefully and prudently, but I do hope that we will see more of these guidance notes coming in, because that comes after consultation, after deliberation, and then what is put out holds the field for a certain period of time. As participants may know, just a few days ago, on November 26th, the CCI also amended the Form 1, where they took away the requirement to talk about the non-compete clause. Earlier the non-compete clause was a matter of huge debate, where clients had contractually wanted to agree to something, but the CCI said no longer than this, these are the conditions, etc. Now what has happened is there is a guidance note in place. And the guidance note talks about what period of time the Commission is comfortable with, which longer period of time the Commission requires the participants to justify. And given that is already out there, the Commission decided, I assume, that let's not clutter the form with what is already out there in the market. It does put a higher burden on the participants to a contract because they don't have the approval of the CCI to that clause when they fill in their Form 1. But given the guidance note, I think that we can turn that into a positive and rely on CCI to basically hold the industry to the standards that it has put in the guidance note. So all these steps, as you can see, are basically encouraging the ease of doing business. I think that the regulator that we have been working with has continued to be more nuanced, friendly to practitioners, willing to listen, willing to be, enter into sensible discussions. And I think that worldwide, we have certainly, as a commission, held our head up high. So to conclude, so that we get the show on the road and we hear the real speakers, I want to thank you, Chairman, and all the CCI members who have taken the time and trouble not only to attend today, but to help all of us in reaching the goal of ease of doing business and getting the show on the road. It's a difficult year, and we hope it'll end soon by God's grace. But otherwise, I would request you to continue and sustain the dialogue between the Commission and the industry. And I'm sure and confident that the trend will continue. So thank you very much, Chairman. Thank you for coming, and we look forward to hearing your keynote address, and to all our members, and of course to the audience as well. Okay, so now we have Mihir. Do I introduce him, Vikas, or do you introduce him? How is it going?
So thank you, Zia. And Mayor, of course, needs no introduction, but just to mention that Mihir is heading and he is the General Counsel Star and Disney India. So with these, may I now request Mihir to make his remarks, please. Thank you.
Yeah. Thank you, Vikas. Thank you, Zia, for the kind introduction. Welcome, Mr. Ashok Kumar, Chairperson of the Competition Commission, and other members of the Commission. Thank you for your presence at the Annual Forum on Competition Law and Practice. I also thank you for taking the time out to address the forum on behalf of the CII. At the same time, I'm very grateful for the CII for this opportunity to speak. Thank you. As Zia mentioned, I think this has been an unprecedented year, and it has seen everyone's lives, without exception, being disrupted like never before. Not only has the personal toll on life and health been severe, but businesses have been impacted severely as well. The Indian economy contracted by almost 24% in the April to June quarter of this fiscal year. This has probably been the worst decline ever recorded since India started recording GDP sometime in the year 1996. Many businesses are fighting to stay alive and adopting to new ways of working. Several sectors have started accelerating a move towards adopting new technologies and business models to survive. I think available data suggests to us that the road to recovery may be long and arduous. In this background, I think one natural question which arises, and probably for this forum and given its nature and profile of participants, is what can be done in terms of competition policy to help alleviate the effects of the pandemic and further further add to the ease of doing business. I think Zia has already mentioned several things that the CCI has undertaken, which have helped in the ease of doing business already. But I have a few suggestions. I have a couple of suggestions, which, if not as answers to this question, at least should serve as topics of debate and discussion during the course of this conference. And I hope will serve as topics of debate and discussion. So the first of them is uniformity in application of competition policy. I mean uniformity in application of certain fundamental core principles of competition policy. If we all agree that the Competition Act is the core legislation which informs competition policy as far as India is concerned, there are a few basic concepts which we can glean from its framework. Some of these may be allowing market forces to operate freely, regulatory intervention in case of market failure on a case-by-case basis without blanket sector-wide impositions, an objective statutory framework which sets out specific instances meriting intervention and the manner in which an assessment of market failure is conducted. In keeping with these principles, the Commission has largely adopted a non-interventionist approach and been light-handed at best when it comes to interventions. Unfortunately, these same competition law principles vary dramatically across sectors based on a sector. To the best of my knowledge, I am not aware of any sectoral regulator which is informed by a similar statutory framework, which tries to harness some of the best practices of competition law. As a consequence, there are many sectors, including the one which is obviously very core to media and entertainment, which is in the television space or otherwise, which has been riddled with interventions. And so are similar other sectors where interventions are commonplace and almost par for the course. So when I say ex ante prescriptions, I mean behavioral remedies or prescriptions which apply as almost a threshold operating requirement. The reason for such practices or tendencies, to my mind, to be deprecated totally is because they proceed on an assumption of almost permanent market failure absent such intervention. There may be justifiable situations for all practical purposes where such intervention may be introduced, let's say essential commodities or in the dispensation of scarce natural resources, but those remain the exception than the rule. To cut a long story short, to narrow down the effect of ex ante regulation or the propensity to intervene regularly to level the playing field, as example from the media and entertainment space. I think at all points of time, we've all at some point or the other lamented about the quality of content available on television, or for that matter, the quality of news coverage. I think it is debate worthy to examine what role regulation has played in affecting or influencing quality. Purely statistically, television in India, and news even more so, is fatally dependent on advertising revenue. As a consequence, all content creators are focused on chasing eyeballs than any higher calling which may have ever informed their passion to create content. We'll all be familiar with news channels always being on a breaking news kind of spree or the incentive to sensationalize. All of these are efforts gravitated towards ensuring that viewers' eyeballs continue to remain on that screen, because ultimately all of it leads to an advertising revenue influx, which is pretty much the live stream for all news channels. As a consequence, I think the question that I had is, what is the solution going forward? Is it possibly the use of the same statutory framework by different sector regulators, similar to what is done in the UK, or mandating the dialogue between the CCI and the sectoral regulator when dealing with issues of competition? My second suggestion is on the digital economy. And when I say digital economy, I mean more in terms of the digital adoption by various sectors across. In some form or the other, every sector has of digital technology or a shift towards digital adoption. The pandemic has actually accelerated this adoption and made the shift for business to survive and to grow. I think largely traditional businesses in India and across the world may have taken a hit due to the pandemic. However, they are trying to innovate, adopt, and be while combating these unfavorable macroeconomic conditions. Notably, retail players have been quick to adapt, innovating and ramping up experiences and safety measures for consumers, thereby building trust and enabling sector's recovery. With the growth of digital businesses, there have, however, been voices of late about the need to regulate them and arguments again around creating a level playing field. In this regard, it is my suggestion that it is important to resist the desire to apply restrictions to new technology and innovation on the back of any clarion cry to field. If at all a level playing field is warranted or justified, it may be addressed by removing existing regulation on traditional models, then to introduce regulation on new technologies. And will not just bad for market players, but also counterproductive for consumers at large. A minor approach, therefore, must be avoided. Innovation, as we all know, fuels the next growth story, the need of which is more acute than ever as we claw back to growth and recovery. It also must be acknowledged that innovation requires an enabling environment. The least that can be done is to remove the incentive to innovate by threatening to introduce regulation. To sum up, in my view, the way forward is increased collaboration between stakeholders and different regulators. I think it has to become par for the course going forward. And active participation and advocacy from the Commission, which could go a long way in setting in place uniform principles for competition policy across sectors. I'm grateful for your time and thank you for your patience and the opportunity. Thank you. Introduce, or you will?
Thank you, Mihir. I think Vikas can now introduce Indrapreet.
Thank you, Mayor. Thank you, Zia. Now, may I request Inpreet Sahani, Group General Counsel and Chief Compliance Officer, Infosys, for her remarks, please. Thank you. Inpreet, you are on mute, please.
A very good morning to everybody, to the chairperson of the commission, other members, Zia, Mihir, and of course, all of the participants. Thank you very much for giving me this opportunity to speak to you today. We meet under strange circumstances. You know, we are in the backdrop of a dual, both health and economic crisis, the likes of which nobody has ever seen in their lifetime before. And as we've sort of moved forward on this, you know, governments across the globe have responded in multiple ways, taking emergency measures to lessen the impact of the lockdown as their economies are facing shrinking demands, disruptive supply chains, limited access to healthcare, other essential goods and services. And as governments have pivoted, so have the businesses and companies. And when the lockdown came, you know, it sort of started off slowly in China and sort of burst on the global scene in an almost, it was almost as if it was unannounced. You know, everybody thought that we were secure. And then companies pivoted very, very quickly. And the first area that attention turned to was the health and safety of our employees. How would we enable sort of working remotely from home, concerns around data protection, cybersecurity, contractual obligations, cash flow issues. These are indeed challenging times for everybody. What was not at the top of the mind was that how do we deal with compliance with competition law in the backdrop of the pandemic? But very quickly, as things unfolded, and you know, we'll hear from many of our really exciting panelists that are going to speak during the course of the day, that how complying with competition law has actually moved near to the top of the agenda for businesses. You know, even in the best of times, it's important that we continue to operate in fair markets. The objective of the competition law, which is in India enacted through the Competition Act, executed by the Competition Commission, is really to ensure that the market is free from practices that can have an adverse impact on competition. You have the ability to protect the interest of the consumers. There's ability to engage in free trade. And what the pandemic does actually makes it even more imperative that the playing field remains fair, right? These challenging times actually, you know, if you go with the principles of economics, the demand and supply, the tendency to take advantage, price gouge, profit on the back of broken supply chains where people are handicapped by reasons of access, not everybody has digital access, makes all of this really, really critical that companies and businesses put compliance of competition law as moving to the near top, right? Health and safety and all of that first. And, you know, here I sort of look to all of our colleagues who are in the in-house world, running businesses, running operations, and would recommend to them that this, you know, if they've not already done so, this would be really a good time for them to review what their compliance program looks like. and where necessary, consult with counsel, outside advisors is appropriate, and make sure that you have a program in place. And the program, I think, should be focused and guided on the following principles. First and foremost, to remember that there is no hiatus or exemption from competition laws, even though we are living in these unprecedented times, which are extremely challenging. The natural tendency in times like this is to gravitate towards people who are facing similar challenges, engage with competition. And a critical part of every compliance program necessarily needs to be that any coordination or any engagement that you have with competition is well reviewed. The do's and don'ts are called out very, very clearly for people who are boots on the ground, your business folks, operational folks, market facing executives. People also have to recognize that if there is something that is being encouraged by the government, also does not provide you with any exemption, immunity, or a sort of free ticket from not complying with these requirements. And then I would say companies who are in market dominant positions in times like this need to tread with even more caution. I think not just in India, but even globally, regulatory agencies are very vigilant and recognize that there's a high probability and an increase for violation with these competition laws as people want to profit from these situations. And so companies need to be conscious of that as they put this together. So, it is with this backdrop, I would like to thank the Competition Commission. I think Zia mentioned it, that the Commission responded to the pandemic very early and put out that advisory in April of 2020, maybe within a month of this issue sort of coming to the ground, and provided clarity as to what was acceptable, fair place, coordination and contact between competition, if it was being done for the benefit of the consumers, being guided by concerns to address issues arising from the pandemic, so long as it was done in a proportionate manner and not being done with the intent to either share sensitive information or circumvent the law, right? So the Commission recognized that, underscored and called out what is actually already built into our framework. And so I think that kind of clarity coming from the Commission is helpful to companies. They know how to draw the boundaries, where to draw the boundaries, what's doable, what's not doable. And that kind of engagement with businesses, which are an important stakeholder in this process, gives clarity of thought as they decide how to move forward, right? This is, again, I think many people have said it, and perhaps you can't say it enough, that these are really times that nobody has seen before. I also would like to talk a little bit about how other countries and other regulatory agencies across the globe have responded to this pandemic. There's always learning as to how other countries are dealing with the same challenges. Some of that may work for India, some of that may not work for India. But we have seen that there's been a little bit of a different tack, particularly coming out of Europe, including UK and Australia, where these agencies have acted with an unprecedented degree of flexibility in providing short-term relief to certain sectors in complying with some parts of their compliance regimes. Essentially, they've allowed sectors that they've deemed to be essential, and with the objective of serving the customer, to soften the application of competition law. For instance, we saw in the UK, supermarket chains were exempt from complying with competition law, especially as it related to supply and distribution of essential services. Norway had a struggling transport sector, so their regulator and the agencies there gave them a short-term break from complying with certain requirements. Similarly, in Australia, we saw that there was interim cooperation allowed in the banking sector, which was to provide relief to companies that were impacted by the pandemic, right? So to that limited, narrow extent. Again, where companies and supermarkets wanted to coordinate with the supply chain and distribution of essential products. The US took a little bit of a different approach to this. The regulatory agencies there, which is the Department of Justice and the Federal Trade Commission, said that they would provide an expedited review process where companies were looking to collaborate on matters that were important to combat the pandemic, and said that they would come back with their review process within 7 days on matters that related to public health and safety. The EU antitrust authorities have also said that they will not intervene against necessary and temporary cooperation, which is intended to avoid supply shortages. Again, I think while these exemptions have come in the Western world, to be clear, they're very narrow. They're either industry specific or scheme specific, and apply in a very limited set of circumstances, and are often accompanied by warnings and severe warnings against unscrupulous business practices. This is not a carte blanche to completely disregard competition law obligations, but have to be viewed narrowly, but give companies the flexibility where cooperation is intended for a larger purpose. It is not unlike what's happening in India, but I think it's more broad-based and more specific. Having said that, these agencies have also said that they're actively reviewing the market, because they know that, you know, every crisis is also an opportunity for a bad actor or businesses to take advantage of these unscrupulous practices. And they will continue to enforce, monitor, and see what's going on. So essentially, I think the challenge across the globe, if anything, you know, there's a common unifying factor as to how companies and countries are dealing with this. Companies, I think, need to recognize that compliance obligations are here to stay. Compliance with the laws remains important. And the exceptions, if any, are narrowly structured. And I thought that providing this global perspective allows us to get a peek into something that we don't look at regularly, right? And we take what we think would be best practices, and, you know, what works for us as a country may not necessarily work for other countries. Again, I think, you know, I would sort of encourage all my colleagues and people in business running compliance departments to stay focused on what they can do to make sure that we all operate in a manner that is compliant, make sure our marketplace remains fair. And I also want to compliment CII, you know, very early on, CII, and I know Zia, your firm was involved, put out a really nifty compliance guidance on what it means to comply with the Competition Act in these COVID times. And it's a great starting place. You know, it spells out at a very high level what the regulatory framework should look like, and would set businesses on their way. And, you know, CII has actually been helpful not only in this area, but also in other areas in providing a plethora of resources to its members. So kudos to you for that as well. So, you know, let me then sort of end my remarks by saying that just as people of the world and humanity, we've shown tremendous tenacity and the ability to adapt to these circumstances, right? Companies used to struggle with, can we allow people to work from home? And then, you know, with the flip of a switch, you have hundreds and thousands and millions of people working from home and doing it well. You know, it looks like, yes, we may have had some operational issues, but we haven't really missed a beat, right? We also began this year by adopting a new vocabulary, you know, asymptomatic, lockdowns, shelter in place, work from home, work from office, work from anywhere, Zoom get-togethers, virtual conferences of this kind. But I'm also a optimist by nature, and I think we're beginning to see the light at the end of the tunnel. And I'm sure as we begin the new year, we'll add new words which will embrace things like vaccine, antibodies, therapeutics, and again, for all of you who are attending this conference, also compliance with the Competition Act. So I hope, with that, wish everybody a wonderful conference, and look forward to seeing many of you in person next year. Thank you again very much for this opportunity.
Thanks, Indra. Many thanks indeed. It is a new vocabulary, and life has just changed. And now, we look forward to the keynote address from our chief guest, our chairperson, Ashok Kumar Gupta. We're all eagerly awaiting to hear from you, sir. So, Vikas, unless you have anything more to add, we should get started and hear our chief guest.
Of course, we request our chief guest, Chairman Sir, Shri Ashok Kumar Gupta, for his keynote address, please. Thank you.
Mr. Vikas Mohan, Ms. Zia Modi, Chairperson, CII National Committee on Regulatory Affairs and co-founder and managing partner, AZB Partners, Mr. Mihil Rale, General Counsel, Star and Disney India, Ms. Inderpreet Sahani, Group General Counsel and Chief Compliance Officer, Infosys, my colleagues from the Commission, distinguished panelists and participants, friends from the media, very good morning to everybody. It's a great pleasure to be at this virtual annual conference on competition law and practice. Over the years, this platform has helped in brainstorming various facets of competition law and enforcement. In that sense, this annual conference provides an excellent place for exchange of ideas that can inform the evolution of competition law. Given the extraordinary circumstances caused by COVID-19, I must commend the efforts of CII for organizing this virtual conference today. Friends, the unabated spread of the COVID-19 has caused unimaginable crises across the globe. Never before in recent history have we encountered a challenge of this enormity that has so profoundly impacted the world and all sectors of economy likewise. A pandemic brings in its wake crises of unprecedented magnitude and also newer opportunities and solutions to counter the same. Such disruptive events not only test resilience and adaptive capacity, but can also unleash forces of innovation and creativity to shape a more sustainable and inclusive future. In crises like this, competition authorities have a paramount role in helping economies to get back on the track. Competition law has seen an exponential growth throughout the world. There are currently more than 130 jurisdictions across the globe that have some form of competition law. As a philosophy, competition law ensures level playing field for all enterprises, promotes vibrancy of economy, and enables common man to reap the benefits of growth. COVID-19 has given an opportunity to reassess working of national economy and reflect on the emergence of digital economy across the nations on a wider scale. Digital economy, e-commerce, and platform markets sound similar tones in every jurisdiction and show similar concerns on the regulatory maps across the world. Competition authorities everywhere are grappling with these concerns for some time now, and the Competition Commission of India is no exception. As I can see from the comprehensive agenda of this conference, a host of competition-related issues of contemporary relevance have been encapsulated. I hope these sessions will not only deal with the main issues, but will also address subtleties involved within these themes. During present challenging time, our efforts at CCI have been to augment the regulatory outreach with stakeholders and we are extensively using digital ways and means to further this. I would like to re-emphasize that CCI believes in consultative and harmonious approach so that the goal of well-functioning markets can be achieved with active cooperation of trade chambers like CII. In the COVID-impacted economy, the task of competition regulators have become formidable as they endeavor to preserve an economic environment in which technology and innovation can flourish while ensuring that the same are not used by enterprises to undermine the competition in the economy. In the digital landscape, amassing a huge data by first movers to the detriment of new entrants and consumers and the phenomena of winners take all have posed objective challenges before the competition authorities. While competition regulators across the world have adapted to new normal and adopted measures to protect markets and economies, in India, CCI, acting proactively, has responded both on the administrative side as well as on the regulatory front. On administrative side, to ensure continuity of work, arrangements have been made to enable parties to file electronically antitrust cases as well as combination notices, including green channel notifications. Further, to ensure that cases do not remain hanging in uncertainty, the Commission is conducting virtual hearings. CCI issued an advisory for guiding businesses during these tough times. It was necessitated due to widespread disruptions in supply chains, including crucial healthcare and other essential services. It was highlighted in the advisory that given the pandemic situation, businesses may need to coordinate certain activities such as data on stock, transport, logistics, R&D, etc., and resorting to such activities would not fall within the presumptions envisaged under Section 3.3 and 19.3 of the Competition Act, provided such arrangements result in increasing efficiencies and such conduct of businesses are necessary and proportionate to address concerns arising from the pandemic. The Commission has responded dynamically in crafting remedies in the wake of COVID-19 and the consequent disruptions brought by it in the economy. The Commission has been cognizant of the economic distress brought about by the pandemic upon small market players, particularly MSMEs. In this, the Commission has been guided by its larger goal of keeping MSMEs going and faster market corrections than penalizing the firms through monetary penalties. In this connection, let me mention that the Commission in its recent interventions has taken due cognizance of cooperation extended by the parties during investigation and inquiry stage and refrained from imposing monetary penalties when taking note of the conduct of the parties. The Commission was satisfied that a simple cease and desist order would suffice to attain market correction. Such accommodative stance of the regulator was devised to meet the extraordinary situation arising out of the global pandemic and was also subject to the specific facts and cooperative and reformed conduct exhibited by the parties. Going forward, please take note, the Commission may assimilate such factors in the decision-making process which will encourage the parties to cease the anti-competitive behavior and thereby bringing about the much-needed market correction faster. The Commission has recently amended the combination regulations to dispense with the requirement of providing information on non-compete arrangements in Form 1. I personally feel that this amendment will provide flexibility to the parties to the combination in negotiating non-compete clauses. Thus, the parties are not bound by general set of standards for assessment of non-compete restrictions which may differ from case to case, especially in these modern business environments. This measure will also reduce the information requirements at the time of notifying the combination. The Commission's Green Channel for automatic approval of combinations has received a positive feedback from the business and industry. 1 out of every 5 cases are filed under Green Channel, demonstrating greater stakeholder confidence. This is a first of its kind trust-based system in the world and should sustain speedy, transparent and accountable merger review, strike a balance between facilitation and enforcement and create a culture of voluntary compliance that supports economic growth. As the new age markets characterized by e-commerce have thrown challenges of newer proportion and nature, the Commission undertook a market study on e-commerce with an objective to comprehend the business practices and contextual provisions in e-commerce and their underlying rationale and implication for competition. Some competition concerns that emerged from the study include lack of platform neutrality, unfair platform business contract terms, existence of platform parity clauses and exclusive agreements, and deep discounting. It is felt that while these issues may be examined within the provisions of competition law, what seems to lie at the core is an imbalance in bargaining power between platforms and businesses. In the current year, private equity investments have surpassed strategic investments in India due to the prevailing pandemic. A new trend has emerged where FDI investments and other foreign investments have been overtaken by PE investments. The Commission has been examining transactions of sub 10% investments in target enterprise by private equity investors where there is even a single board seat in the target enterprise. Since many of these PE investments are in multiple firms of the same industry, leading to product market overlaps, the issue of common ownership by minority shareholders across firms and its impact on competition needs to be understood. In order to understand the trends and patterns of common ownership by PE investors across sectors in India, the Commission is shortly going to conduct a market study. This study aims to gauge the common PE investors' underlying incentives and motivations behind such investments. It is important to look at the rights they get to protect their legitimate financial interests from their shareholdings and whether these rights can translate into their ability to influence the decision of a firm, consequently impacting competition, or whether the investor and the company holding the minority shareholding will classify as a passive investor. This question needs to be answered. This study would help us in identifying the kind of shareholding rights available to common shareholders, the type of influence these rights provide, and the available safeguards in companies' policies for mitigating competition concerns, if any. In October 2020, the Competition Commission of India also launched a market study of the pharmaceutical sector in India. The pharmaceutical sector plays a pivotal role in the public health agenda of any nation. Quality, access, and affordability of medicines are key determinants of the overall quality of public health. However, owing to the inherent information asymmetry between consumers and suppliers of medicines, markets by themselves may not deliver optimal outcomes in terms of these parameters. To this end, the study intends to focus on the distribution segment of the pharmaceutical market in India with a view to understand discounts and margins policies at wholesale and retail levels of the distribution system, the role of trade associations vis-a-vis various aspects of the distribution business, a regulatory rationalization of trade margins and its impact on price and competition, the impact of e-commerce on price and competition. Besides, the study also aims to investigate the extent of proliferation of branded generic drugs in India with its implications for competition and to assess potential hurdles, if any, in entry of bioequivalent or biosimilar drugs in India. CCI has been doing competition advocacy since its inception. With a decade of enforcement experience, it was brought to the fore that there have been inherent issues in public procurement and tender designs vis-a-vis competition proliferation. Public procurement in India as a percentage of GDP is estimated between 20% to 22%. For the size of Indian economy at $2.7 trillion US, public procurement amounts to the tune of $500 billion US annually. Public sector undertakings are a major contributor to public procurement of works, goods and services. CCI has learned through its experience that it is not enough to correct markets on the supply side through enforcement orders and advocacy. Rather, effective approach is required to work on the procurer's side as well. In order to broaden the reach and disseminate the idea of competition law to states, CCI launched a scheme named State Resource Person Scheme, which was implemented from January 2020. This endeavor was imperative for imparting training to state government officials in general and procurement officials in specific, In furtherance of the objective of the scheme, CCI has conducted so far 41 advocacy programs for the procurement officials under the scheme. Response of the participating states has been overwhelming. I would like to emphasize that CCI has not only brought out an advisory for enterprises during COVID-19 times, but has also cooperated with BRICS counterparts and signed a statement of the BRICS competition authorities on COVID-19, expressing intention to join efforts in combating the negative economic consequences caused by COVID-19, sharing experiences, information and practices on developing competition during and after the pandemic for the benefit of the society and economies. Our endeavor has always been to take competition regulation wider and make it accessible to one and all. I am happy to share that in our approach, we get support of all stakeholders. At the end, I would like to appreciate the efforts of CCI in organizing this event and look forward to a productive outcome of this annual event. Human interaction is key to growth and communication is an integral part. Such events not only help us to introspect but also bring new ideas to current practice of competition law. A number of good suggestions have been articulated in this inaugural session. They will definitely help the Commission in taking informed decisions. I believe as the sessions in the conference unfold, it will usher in a more synergetic and symbiotic approach between CCI and CII to address and tide over challenges of pandemic, new age markets, and any other challenge to build a robust economy through fair competition in all sectors. Thank you very much.
Thank you. Thank you very much. And as the audience can see, Mr. Gupta has covered a wide range of issues. Chairperson has talked about, I think what is most important is that for me as a M&A practitioner, looks like if the private equity investments have surpassed strategics, it clearly shows two things. One is the sign of unabated interest in our country and CCI's recognition of PE emerging as an important class of stakeholders and to address issues that they have as well. Let me thank Mihir first by thanking him on his comments about the need to innovate and the uniformity of approach that I think he is often faced with between several regulators. So we feel his pain, but I think that bringing this to the attention of the Commission is important. I think Indrapreet's comment that everybody has to review their compliance program is an obvious but an imperative exercise. Apart from the new vocabulary we have, the new temptation, or not temptation really, the new urgency to sometimes overlook some compliance steps because of COVID faces all of us. And I think that if the program is now re-looked at with COVID in mind and the new compliance issues and the relaxations, that is a very worthwhile exercise to all of the participants who are listening in. I think the comment that Indrapreet made that, certain relief is given to certain sectors globally would be important, I think, Indrapreet, for our Commission also to know what has happened, because that will be useful for them also to apply their mind to see if they need to do something putting on the India hat. If certain sectors are declared essential, how flexible are the global regulators being? And maybe Vikas can just coordinate with someone in your team because of your global reach as INFI, that we can maybe bring these comments into our Commission's thought process as well. Our chairperson has talked about something I didn't know about, which is the largeness of the public procurement exercise in this country. And it's absolutely right. It's not only the sellers, but the buyers that need the training. So I think that what we would urge the commission members and the chairperson is to see what comments and recommendations and suggestions come out, not only of the inaugural session, but also as the session goes through. Maybe CII can collate these suggestions in a one-pager and pass them on to the commission to the extent that they are responsible recommendations. And I think that this is our annual event where we say thank you. Thank you for listening to us. Thank you for being so participative with us. And thank you for always keeping an open mind, understanding our pain points, letting us understand your point of view. And we hope that all of you stay well and safe and come back soon to our offices. Okay, Vikas, over to you.
Thank you, Zia. And, Chairperson, I echo and wish to convey sincere thanks on behalf of CII for your time, for your address. You set the context for today's conference, where there are 4 dedicated sessions focused on specific issues. And we would like to assure from CII in terms of the inputs or in terms of any support which is required on policy streamlining, that CII to the regulatory committee would continue supporting that. And of course, thank you for being so proactive and open to listen to the industry views. So thank you very much for your time, and thanks to the Commission for all the support for organizing this conference. Thanks to Indeed, thanks to Mayor, and of course, thanks to Zia, as always, for all the support. Thank you. Thank you all. Thank you.
Thank you very much.
Thank you.
Very
Bye-bye.
much. All the best.
Bye. All the best.
The next session is about to start in a couple of minutes. So if you would like to join next session, please do so, because that is going to start in next, I think, 2 minutes time. Thank you.